soldier of the cross, a follower of the Lamb. And shall I fear to own his cause, or blush to speak his name? Shall I be carried to the skies on flowery beds of ease, whilst others fought to win the prize and sailed on bloody seas?
Well, I want to share with you a legal brief that I've written. I want to give you a summary of the brief, and this is going to be bilingual. Zaira Alleman is going to translate.
Okay. Este es un resumen de unos argumentos que él escribió y van a ser bilingües.
And after we read this summary, this is a 50-page legal brief. It's after we read the summary of it, I interviewed Michael Said, an immigration attorney, and we discuss it. And he discusses his the merits of using this brief in an actual immigration deportation case. So, but here's the summary. These arguments. Oh, go ahead and translate that.
Después de este resumen, él entrevistó al abogado de leyes Michael Sear, que él da su opinión en este resumen y dice todos los méritos que tiene este resumen.
These arguments are offered in defense of those who have become undocumented immigrants through no action of their own, and who are thus innocent of violating our laws. This could describe possibly half of undocumented immigrants. These arguments additionally challenge the constitutionality of numerical limitations. There's a phrase in the 14th Amendment called equal protection of the laws, and in the 5th Amendment there's a phrase called due process. These phrases require reasonable access to the fundamental constitutional right of liberty for all immigration applicants, whether living here or abroad, who meet the qualifications which citizens meet, and who have not done anything which would be crimes if citizens did them.
Estos argumentos son ofrecidos en defensa de quienes se han convertido en inmigrantes indocumentados por ninguna acción propia y quien por eso son inocentes de violar nuestras leyes. Esto puede escribir posiblemente la mitad de inmigrantes indocumentados. Estos argumentos adicionalmente retan la constitucionalidad de las limitaciones numéricas, protección igual de leyes de la enmienda número 14 y el proceso debido de la enmienda número 5. Necesita acceso razonable al derecho constitucional de libertad fundamental para todos los solicitantes, los que viven aquí o no, que incumplen las calificaciones de los ciudadanos y que no han hecho algún crimen así reconocido si los ciudadanos lo hicieran.
Those who are under the jurisdiction of our laws and thus entitled to their equal protection include everyone whose liberties and rights are affected by our laws, whether living here or abroad, this brief argues.
Aquellos que están bajo la jurisdicción de nuestras leyes y así tienen derecho a la protección igual, incluyendo a todos los cuales las libertades y derechos son afectados por nuestras leyes, los que vivan acá o no.
Plyler versus Doe, that's a Supreme Court case in 1982, said that even those who reside here illegally have fundamental rights which cannot constitutionally be abridged or cut short except by laws which can pass, the word for it is strict scrutiny. Now, of course, courts restrict the liberty of lawbreakers all the time. Our police arrest them, our courts try them, and our jails hold them. But immigration law violates fundamental rights when it prosecutes millions of U.S. residents who have broken no laws.
Claire Bidot es un caso de la Corte Suprema de 1982 y ha dicho que aún los que viven acá ilegalmente tienen derechos fundamentales que no pueden ser restringidos por la Constitución excepto por las leyes que puedan pasar un estricto escrutinio. Por supuesto, las cortes restringen las libertades de los hacedores de leyes todo el tiempo. Nuestra policía los arresta, nuestras cortes los prueban y nuestras cárceles los acogen. Mas la ley de inmigración viola los derechos fundamentales cuando enjuicia a millones de residentes estadounidenses que no han violado las leyes.
Millions of undocumented immigrants have broken no laws, yet are under a cloud through which the rays of liberty can never shine. They are in 6 categories.
Millones de indocumentados que no han violado las leyes, pero están bajo una nube en la cual los rayos de libertad nunca podrán brillar, y están en 6 categorías.
The first category of immigrants who have broken no laws is undocumented immigrants brought here as babies or as children with no voice in their coming here. They have no culpability. That's a legal word for legal responsibility. They have no mens rea. It's a Latin word for it means they have no criminal intent. It's a stronger case when they are not citizens of any other country either, so that it is impossible for them, even after they become adults, to bring themselves into compliance with our laws by leaving, because there's nowhere they can go. If the case is so strong that even USCIS prosecutors are ashamed to prosecute them, the immigrant might consider being an appellant and suing because they are denied opportunities by laws that criminalize their very existence.
La primera categoría, inmigrantes indocumentados traídos acá como bebés y como niños sin voz ni voto en su traída acá. No tienen culpabilidad, o sea, responsabilidad legal o mens rea, que es una palabra de latín que es intención criminal. Es un caso fuerte cuando no son ciudadanos de otro país también, así que es imposible para ellos, después de que se conviertan en adultos, a cumplir nuestras leyes al irse, porque no tienen dónde ir. Si el caso es tan fuerte que aún los fiscales del UCI estarán avergonzados de procesarlos, el migrante puede considerar ser un apelante en demandas porque son negadas oportunidades por leyes que criminalizan su propia existencia.
I want to add a little bit to what I've written here. Oh, good, they kept going. There are people who cannot be deported because they're born here, they know our language, they don't know how to function in any other country, they don't know any other languages besides English, and they're not citizens of any other country, so no other country will receive them, so we can't deport them. But they're not here legally, according to our laws, so the federal courts are actually divided over whether it's the right thing to do to keep them in jail forever, for the rest of their lives, even though they've violated no laws. They have a term for it. They call it indefinite detention. And our federal courts are actually divided over this. Some think, well, let's do that. Others say, let's not.
En la Corte Federal están dos grupos divididos sobre si los inmigrantes ilegales que están acá debieran ser deportados a sus países de origen o no. Y esto se basa en que muchos de ellos no recuerdan su país, han estado acá toda su vida y no saben el idioma de ese país, así que están discutiendo si deberían mantenerlos en la cárcel por el resto de su vida o si deberían deportarlos.
All right, prue-call cases is the second category of immigrants who have broken no laws, but we call them illegals. Prue-call stands as P-R-U-C-O-L, persons residing under color of law.
La segunda categoría son casos procol y son personas que están bajo la jurisdicción de una ley de color.
In procol cases, where a defendant came to be undocumented because bureaucrats failed to act on applications as our laws require, while defendants' living arrangements were based on a good faith expectation that the bureaucrats would follow the law.
Son cuando el defensor vino a ser indocumentado porque los burócratas no pudieron actuar en las aplicaciones como nuestras leyes requieren. Cuando los arreglos de vivienda del defensor fueron basados en buena expectativa de fe que los burócratas seguirían la ley.
Here's an example that happens a lot. An immigrant marries a citizen and comes here on a 6-month visa and immediately applies for an adjustment of status. The USCIS gives applicants 8 months of protection from deportation after the visa expires, while the applicant is waiting for the ruling which should automatically approve them. That 8-month protection supports a good faith expectation, wouldn't you think, that the USCIS will rule within that 8 months after the 6 months. But the USCIS often delays 5 years.
Por ejemplo, esto pasa muchas veces. Un inmigrante se casa con un ciudadano y viene acá con una visa para 6 meses. Y inmediatamente aplica para un cambio de estatus. El UCIS da a los solicitantes 8 meses de protección de la deportación después de que la visa expire. Cuando el solicitante está esperando por el fallo del juez que automáticamente debiera aprobarlos, los 8 meses de protección apoyan una expectación de buena fe que la UCIS los pronunciaría en ese plazo. Mas la UCIS a veces se tarda hasta 5 años.
It would be a stronger case if the applicant can't afford to satisfy our laws by moving to her home country because her money is tied up in lawyers trying to rouse bureaucrats out of the Rip Van Winkle contest. The case is still stronger if the defendant has been sending money to help relatives back home who otherwise are at grave risk of serious injury, of death, due to starvation, lack of medical care, and having to work in unsafe areas. The case is still stronger if the applicant has given birth to a citizen child during the 6 months and moving out of the U.S. with the baby to the middle of a drug war in her home country would violate our child neglect laws.
El caso es más fuerte cuando el solicitante no puede satisfacer nuestras leyes a moverse a su país porque su dinero está amarrado con los abogados tratando de despertar a burócratas fuera de su competición de Rip Van Winkle. El caso es aún más fuerte si el defensor ha comenzado a mandar dinero a su país a parientes que de alguna u otra manera están en peligro de lesión o muerte a causa de hambre, falta de cuidado médico y tener que trabajar en áreas peligrosas. El caso es aún más fuerte cuando el solicitante ha dado a luz a un ciudadano durante los 6 meses y moverse de los Estados Unidos con el bebé a su país que está en medio de una guerra de drogas violara nuestras leyes de abandono infantil.
And if the mother, her 6 months visa is expired, her 8 months extension is expiring, she's got a baby, she's bought a home, they're expecting the bureaucrats to move on the applications. If she at that point delays leaving the country by a week or so, and later it can be proved in court that she was here illegally, then she has to wait 10 years before she can return to the United States legally.
Si la madre que mientras ya se le venció la visa y está esperando y tiene se le está agotando los 8 meses de protección y tiene el bebé acá y ha comprado una casa y tarda más para irse a su país, se puede probar en la corte cuando ya están revisando el caso que estuvo acá ilegalmente y se puede que no pueden fallar que no regrese y tendrá que esperar 10 años.
The third category of immigrants who have broken no laws is victims of status rulings conflicts. Let's say the defendant was ruled legal by the State Department or by the USCIS or by the courts. And the immigrant, trusting in good faith in the authority of that branch to rule on his status, the defendant sat down the roots, bought a home, had married, had babies, only to have another one of the three authorities then rule differently. Now, depending on the circumstances, such a case could invoke speedy trial and double jeopardy legal issues.
Víctimas de estatus de conflicto, la sentencia es la categoría número 3. El defensor fue sentenciado legal por el Departamento del Estado, la UCI o por las Cortes, confiando en buena fe en la autoridad de que la rama que sentencia en estatus. El defensor pone sus raíces, solo para tener algo en los otros tres fallar diferente. Dependiendo de las circunstancias, tal caso pudiera invocar un speedy trial, que es un juicio rápido, y double jeopardy, que es procesamiento por segunda vez.
A fourth category of people who have broken no laws and yet whom we call illegal are life-saving heroes. Now, let me say again, what we're reading here is a summary of a legal brief designed for people in these categories to defend themselves in court and also to challenge the constitutionality of our present immigration laws. So, life-saving heroes. Now, when a defendant's violations of our laws saved human lives through the defendant sending life-saving money to his family in his home country to prevent starvation or to provide medical care or to enable a move to a safer area, then our necessity defense and defense of others' laws and defenses often rule that the defendant did not violate our laws.
La cuarta categoría son héroes salvavidas. Cuando el defensor violó nuestras leyes para salvar vidas humanas a través del defensor mandando dinero salvavidas para su familia en su país, para prevenir hambruna, proveer cuidado médico o ayudar a que se muevan a una área más segura. Nuestra necesidad de defensa y defensa de otros defensas a veces sentencian que el defensor no violó nuestras leyes.
A fifth category of people whom this brief would offers to defend would be people charged with violating immigration laws, which create and where the laws themselves create a denial of fundamental rights from which citizens are exempt, and which no citizen would tolerate were he in the immigrant's shoes. Laws which restrict liberties of people are fine if they're invoked by the defendant's actions deemed criminal by lawmakers or by defendant's lack of qualifications, and if citizens are not exempt from them. But when fundamental constitutional rights like liberty are substantially denied a whole population group without regard to actions or qualifications, by laws that are not, in the court's words, narrowly tailored to serve a compelling government interest by the least restrictive means possible, they violate equal protection of the laws and due process or clauses from the 14th and 5th Amendments. Has there been anything approaching national consensus on what compelling government interest is served by numerical limitations? Most Americans, especially anti-immigrant conservatives, haven't even heard of numerical limitations.
La quinta categoría son cualquier defensor acusado con violar las leyes de inmigración que crean depravación de derechos fundamentales, de los cuales nuestros ciudadanos son excluidos y en cual ningún ciudadano toleraría si él estuviera en los zapatos del inmigrante. Leyes que restringen las libertades de gentes también si son invocadas por acciones del defensor nombradas criminales por los hacedores de leyes o por la falta de calificaciones y si los ciudadanos no son excluidos de ello. Pero cuando los derechos fundamentales, constitucionales como la libertad son negados, un grupo entero de la población sin cuidado a las acciones de las calificaciones por leyes que no son ceñidas estrictamente para servir a un interés gubernamental irresistible por el medio menos restrictivo posible, violan igual protección de las leyes y el debido proceso que están en las enmiendas 14 y 5. Han hecho algo que se acerque a un consenso nacional en que un interés nacional resistible es servido por limitaciones numéricas. Muchos americanos, especialmente los conservadores anti-inmigrantes, nunca han escuchado de ellos.
Now, a sixth category of people that I want to defend through these legal arguments are not people that we call illegals. They are applicants for immigration living abroad. But I would like for them to be able to sue because they are denied a line or an opportunity to apply by laws that have no regard for their actions or qualifications. They could have co-defendants to help give them standing to sue, which could include citizens who are siblings, cousins, aunts, or uncles.
La sexta categoría son para los demandantes de inmigración no acusados con estar aquí ilegalmente, que pueden estar demandando porque son negados una línea o oportunidad de aplicar, sin el cuidado de sus calificaciones o acciones. Los codefensores que ayudarían a su posición incluirían a hermanos ciudadanos, primos, tías o tíos.
This sixth category of arguments explores the boundaries of the meaning of the word jurisdiction in determining who merits equal protection of the laws. The 14th Amendment says everyone who is under the jurisdiction of our laws, of a state's laws, must be given the equal protection of those laws. The 5th Amendment uses the phrase due process to apply the same principle to federal laws. Does the responsibility of our lawmakers and courts to apply our laws fairly, equally, to everybody, indeed end at our borders?
La sexta categoría de argumentos explora los límites del significado de jurisdicción, en que determinando los méritos de protección igual de las leyes, que la enmienda número 14 dice que cualquiera que esté bajo la jurisdicción de las leyes de un estado deben ser dadas las mismas protecciones de sus leyes. La enmienda número 5 usa la frase proceso debido para aplicar el mismo principio a las leyes federales. Tienen la responsabilidad nuestros hacedores de leyes y cortes para aplicar nuestras leyes justamente, igualmente, a todos en verdad. ¿Terminan nuestras fronteras?
Relief for these plaintiffs relies on the assumption that to the extent our laws affect the liberties of human beings, they must treat all whom they affect equally. They must be fair. They must be equal. Liberty cannot be rationed, given by lottery to a tiny fraction of those praying for it. Our entrance requirements must be the same for all. Our Constitution requires equal opportunity immigration.
Alivio para estos demandantes depende de la asunción a la medida de nuestras leyes afecten las libertades de seres humanos. Debieran tratar a todos los que afectan igualmente. Tienen que ser justos. Tienen que ser iguales. La libertad no debiera ser racionada, dada por lotería a una pequeña fracción para aquellos que están orando por eso. Nuestros requerimientos de entrada deberían ser lo mismo. Nuestra Constitución requiere una oportunidad igual.
If Congress has authority to deliberately make laws that are unfair and unequal, do they not have unlimited power to do so? If Congress is excused from enacting equal protection of the laws, which is the phrase which ended slavery, towards any group of human beings, what other constitutional restraint prevents them from bringing in immigrants to be treated as cruelly as slaves, or indeed to be sold as slaves? What constitutional restraint prevents Congress from bringing in citizens to be sold as slaves?
Si el Congreso tiene autoridad para deliberadamente hacer leyes que son injustas e iniguales, ¿no tienen el poder para hacerlo? Si el Congreso es excusado de promulgar protección igual de las leyes, la frase que acabó con la esclavitud, hacia cualquier grupo de seres humanos, ¿qué otro restringimiento constitucional previene que ellos traigan inmigrantes para ser tratados tan cuales como esclavos, o vendidos en verdad como esclavos? ¿Qué otro restringimiento constitucional previene que ellos traigan a ciudadanos vendidos como esclavos?
Liberty is no mere penumbra of a right. That's the kind of a shadowy right supporting Roe versus Wade's right to abortion. Liberty is an enumerated fundamental right. That means it's a right listed in the opening sentence of the Constitution. It is also in the Declaration of Independence, where it is the second right listed after the right to life.
Libertad no es ninguna pequeña penumbra de un derecho del tipo de derecho oscuro, apoyando a Roe v. Wade, el derecho al aborto, pero un derecho fundamental enumerado. Es un derecho especificado en la primera sentencia de la Constitución. Está también en la Declaración, a donde está el segundo derecho mencionado, después del derecho de vida.
No one has asked the court to rule on whether this alleged need to limit immigration creates a sufficient, compelling government interest to justify rationing liberty through numerical limitations. Rationing liberty is, what we have is a literal lottery of enumerated fundamental rights. And we're talking about rationing them to innocent U.S. residents who have broken no laws. No court has been presented with this issue.
Nadie le ha pedido a la Corte de juzgar si alegadamente necesita limitar la inmigración, si en verdad crea un interés gubernamental irresistible, suficiente para racionar la libertad a través de limitaciones numéricas, que son literalmente lotería de derechos fundamentales enumerados a residentes estadounidenses inocentes que no han violado las leyes.
How about population reduction? Is that such a compelling government need that can such a government interest be asserted as long as population still shift from farms to cities, and as long as people regard as luxuries the technologies only possible through large, free, peaceful populations? And as long as federal courthouses are placed in the largest cities.
¿Qué tal la reducción de población? ¿Puede un interés del gobierno ser acertado? Siempre y cuando la población se mueva de las granjas a las ciudades, la gente creen como lujos las tecnologías solo posible a través de poblaciones grandes y libres. ¿Y cortes federales se construyen las más grandes ciudades?
Plyler mentions an additional test which a law must pass before its restriction of a fundamental right can be constitutional. The cost to the nation.
Plyler menciona un examen adicional en cual una ley debe pasar antes de su restricción de un derecho fundamental pueda ser constitucional, que es el costo de la nación.
Not only must the law not unnecessarily restrict rights, but it must not create unacceptable side effects which outweigh the law's compelling government interest. The cost to the nation of numerical limitations is our national security. Border agents could easily catch our few thousand violent threats if they weren't overwhelmed by having to hunt down millions guilty of hard work. We would no longer have a huge illegal haystack in which violent criminals hide if our line welcomed all who obey the same laws which citizens obey. 99% of our present illegal caseload would sign up to be in the system.
No solamente puede la ley no necesariamente restringir derechos, pero no deben crear efectos secundarios inaceptables, que pesan más que el interés irresistible gubernamental. El costo de la nación, de limitaciones numéricas, es nuestra seguridad nacional. Agentes de la frontera pudieran fácilmente atrapar nuestros pocos miles de amenazas, si no tuvieran que estar abrumados por atrapar a millones de culpables de trabajar duro. Ya no tuviéramos un montón de paja de ilegales en cual criminales violentos se esconden, si nuestra línea diera bienvenida a todos que obedecen las mismas leyes que los ciudadanos. 99% de nuestros casos ilegales se inscribieron para estar en el sistema.
Can the court count as a compelling government interest the legislative goal of deporting millions of U.S. residents or any other goal which is, as a practical matter, impossible, which has never been remotely met, which Congress refuses to seriously fund, and which would become theoretically possible only at the cost of our freedoms as we know them, through the complete loss of privacy and the absolute power of Big Brother's national tracking bureaucracy over citizens in every area of life.
¿Puede la Corte contar como un interés irresistible gubernamental la meta legislativa de deportar a millones de residentes estadounidenses? ¿O cualquier otra meta que es prácticamente un asunto imposible, que nunca ha sido remotamente conocido, cual el Congreso rechaza de apoyar seriamente, y cual teóricamente fuera posible solo al costo de nuestras libertades como las conocemos, a través de la pérdida completa de nuestra privacidad y el poder absoluto de Big Brother seguimiento burócrata sobre todos los ciudadanos en todas las áreas de la vida?
When congressional action has utterly and decisively abandoned a goal, can statements about congressional intentions by a congressional minority support the finding that the goal is a compelling government interest?
Cuando la acción del Congreso ha abandonado por completo y de manera decisiva una meta, ¿pueden declaraciones acerca de las intenciones del Congreso por una minoría del Congreso apoyar la conclusión que la meta es un interés gubernamental irresistible?
Let me see if I can summarize. The Supreme Court has often said that fundamental rights can be abridged in order to, abridged means limited, in order to meet some compelling government interest like speech, is a fundamental right. We can abridge it. We can say you can't yell fire in a crowded theater because the government has an interest in people not being trampled to death.
El Congreso ha dicho muchas veces que puede restringir algunos de los derechos fundamentales si sirven a un interés gubernamental irresistible. Por ejemplo, el derecho al habla. Uno no puede gritar fuego en un teatro porque está lleno de personas y el gobierno no quiere que tanta gente se golpee porque alguien gritó fuego.
And no one can dispute that immigration laws ration liberty to millions of U.S. residents.
Nadie puede discutir que las leyes de inmigración racionan la libertad a millones de inmigrantes.
And next we have Michael Said, an immigration attorney, commenting on this brief. He read all 50 pages and he's given a copy to one of his other attorneys in his office, and maybe he is ready to start actually using some of these arguments.
Y después tenemos a Michael Said, que es un abogado de inmigración que ha leído todas las 50 páginas de estos argumentos y que él también les va a dar a uno de sus otros compañeros abogados para que ellos puedan usarlos.
And I just want to thank you again, Sarah, for writing out the translation and for reading it here on camera. Michael Said, immigration attorney here on Southwest 9th. Thank you for reading my legal ideas, and I'm anxious to hear your evaluation of them.
Pleasure. It's always a pleasure talking to you, and you and I have had exchanges previously. I did read the two briefs. They were very interesting, very good ideas. A lot of research has gone into it, that was clear. A large amount of cites, which is always good when you're dealing with immigration law, because cites are what wins the case. Some of the ideas I would, and before we got on camera, I asked your permission to use some of those parts of your brief, some of the cites. I think the analysis is very good, and I believe also that you look at it from a context both of a Christian context and of a legal context. I think that a lot of times the fact that this also involves some of the tenets of Christianity are overlooked, both by, especially by those people in power. They don't seem to want to talk about that, but I believe there is some need to look at that. So yes, I read it and it was very good. It's very good.
I talked to I don't know if it was I talked to a field director for the Rick Perry campaign this morning, and another person, a lawyer actually, working in the campaign. And the lawyer's bottom line was, well, you can't have a law which lets these people just come here and then all of a sudden have a bunch of rights. But I guess the thrust of my argument is that we have something like 2.7 million people here who were brought here as babies or as children. They did not participate in coming here, and now that they're here, they have many of them have no place to go because they're not a citizen in any other country. They don't know how to function in any other country, and our law allows them no access to liberty for the rest of their lives. We just don't go around in this country putting people in jail for the sins of their parents. And yes, that's what we're doing in this situation.
Yes, you're absolutely correct. Immigration law is one of the few laws, if not the only law, where children pay for the sins of their parents. Matter of fact, this morning I got a phone call from a gentleman who, in a school system here in Iowa, a gentleman that I know very well, and he called me because he had two students that he knew for years who had been brought by their parents, they're not babies, that abandoned. Both of them are now 18 and 19 years old, graduated from high school summa cum laude, and don't know any other country than this one. Don't speak any other language than English, and yet potentially, if they're caught tomorrow, and I told him that, and if they're caught tomorrow, I'm sad to say there is nothing these kids could do. Now, the sad thing is that in one way, our politicians, especially our politicians, are fooling themselves. If you believe for one instance that a young man who has nothing in Mexico or in Guatemala, who doesn't even speak the language, and is deported, and upon deportation is going to say, you know what, after all, I don't want to break the laws of the United States, I shall never come back. If you believe that, then we're in serious trouble. What happens is these people get back home, they have nothing, they have no contact, no ties to the culture, no language, and what do? They come back. And now we are having this cycle of people coming back, breaking the law. Now they're breaking the law because they've been deported. Previously there was no breaking of the law. Now they are breaking the law because they've been deported. This is even worse in the case of husbands and wives. Seriously, anybody believes that a husband or a wife is going to stay away from their children? Come on. Either, if you believe that, you either have never been married, don't love your wife, have no kids, or don't love your kids. Because that's the only way why you would say, oh, I'm gone, I'm not coming back. If you deported me, I don't care what wall you built. I don't care what you do, I would come back to my family. My wife and my children are here, I will always come back. So instead of fooling ourselves, how about looking on how to fix the problem? How to fix the problem in our favor? How about fixing the problem so that people pay taxes? How about then paying Social Security so that when you and I retire, there is money in Social Security? That's what we should be looking at, instead of wasting millions of dollars to deport people who have no criminal records. Now, I'm not talking about people who have criminal records, that's totally different. But people who have no criminal record, let's be serious.
The most tragic case to me seems when you can't even deport them because there's no country that will receive them. They're not citizens of anywhere. And so our courts appear to be arguing amongst themselves whether indefinite detention of these people is constitutional.
It's simply sad that we talk about it. In my country, we're talking about indefinite detention. Are we going backwards?
In other words, by indefinite detention, we're talking about keeping people in jail longer than any conviction for any violation of any law would provide for.
And that is correct. I understand that.
I said this for the audience.
Yes, and yes, this is where the problem occurs. Let's say you are here. Let's say you are here undocumented. That you are a peewee, a person who entered without inspection, because that's the legal term. That you are a peewee, and that you are here. Peewee, person who entered. The legal term for a person who comes into this country or enters this country. You can only enter this country in two ways. And the legal terms are with inspection or without inspection. So you refer to a person as an iwi, entry without inspection. And so a person who entered without inspection is a peewee, person who entered without inspection, peewee. Now I understand that doesn't sound dangerous, and you know, this sounds more like a teddy bear. So yes, we have to call them by nasty little names like illegals. But the legal term is evil, so let's use the legal term, okay? So use the legal term. Yes, so the sad thing is we are going to start throwing people in jail at the average cost of $55,000 a year because they have been here without our authorization, and we cannot deport them. $55,000 a year. I mean, that's ridiculous. It's just absolutely ridiculous.
So do you think there's any chance of finding a case where someone could make these arguments and could overturn the constitutionality of these immigration policies?
There are plenty of cases, but there has to be a willingness on the part of the judicial and on the part of the Congress. As long as you don't have a willingness on the part of the judicial to look at the impact of immigration and to look in the Congress to realize that it is an enormous amount of time, nothing is going to change. For example, let me give you one quick example. We deport parents of American children. In a lot of cases, these parents take their U.S. children with them. Now, let's hypothetically say that you deport me back to Guatemala. My son is a United States citizen. He's not a Guatemaltec. He's a United States citizen. So by law, he will be allowed to only go to school 1 year. Now, Guatemalan education system is not the U.S. So let's say he goes to school for 1 year, then he goes and works on, in the field. So when he turns 18, he says, "Hey, Mom, Dad, I'm an American after all, right? I'm going back to the United States." Now, he can come back. He's a United States citizen. He comes back. He has no education, doesn't speak English, therefore has no chance to advancement. Now, doesn't that sound familiar? It sounds very familiar to me, and it goes back to the African Americans. The Supreme Court has said, separate but equal is not acceptable. You cannot create a second-class citizenship. Yet that's what we do every day by deporting parents with United States children. Yet, the court that says, that's okay. How can you do that? How can you say it's okay if you previously said you cannot create a second-class citizenship? These kids will never have the same advantages. These citizens will never have the same advantages as somebody who grew up here. But there's a lack of willingness on the part of the court system and of the Congress to address the issue, and that's the problem.
What is a couple of things now. I forgot what it was.
Take your time.
What do you think of the argument that the word jurisdiction applies to, in the 14th Amendment, applies to everybody whose liberties are affected by our laws? So that people applying from abroad, even though they don't live within the territorial jurisdiction of the United States, should have laws governing the acceptance of their immigration applications that are fair and that offer equal opportunity for all, except as what might be related to one's actions or qualifications.
That's correct. Everybody should have the same opportunity, but that's not the case. Immigration will say to you, we are colorblind. I'm sorry to say, no, you are not colorblind. If you're a Swedish person, your chances of getting, something here in the United States is much higher than if you are from Africa or Latin America. It's a sad.
Well, of course it's not the case. The question is it a valid, by valid I mean, is it the truth? is it a serious legal argument that should be presented to a court? And you said before that it depends on the willingness of the judiciary to address these, but how do you know that without bringing to them a case?
Absolutely. I mean, that's the point. I mean, cases have to be presented. There has to be a case. There has to be a lawyer willing to present new arguments, or else the judiciary doesn't move forward. You know, the law really is a living, breathing animal that changes with time, changes with factors that, you know, of everyday life. We are no longer in the 14th century, so let's be honest. The laws need to change. We have different laws than the 14th century. The issue is there has to be a willingness by people to come forward and present the arguments, and the judiciary to look at it in an open mind, and not go and not look at it with a closed mind from the beginning. Clearly, where you file and where you have a case is very important. I mean, there are certain circuits where, as an immigrant, you have a much better chance of getting a fair hearing than in others.
See, from my perspective, working with pro-life law, not as a lawyer, but as a, you know, just as an activist, I've learned to have a longer term view of strategy than just what's going to work this year.
But you have to.
But 37 years now, we've been working on this, and I found out that it's not just a part of it's not completely up to the judiciary. The judiciary is subject to Congress if Congress has the courage to use what levers it has, and Congress is subject to the people if they're willing to use their levers on Congress. So it's really a kind of national education, and but the thing it has to start with is a true position, an argument or a position that represents truth, that incorporates reality.
That's the biggest problem. I think you pointed out two important factors. You pointed out education, and that is a major problem. Majority of U.S. citizens have no idea about immigration law, except what they hear on, you know, television, and most of what you hear on television is spewed forward by people who have no idea what they're talking about. That's even sadder. So there's a total lack of education. I've given speeches. A lot of lawyers in Des Moines have given speeches to different groups, and most of us will have the same reaction when we explain the immigration laws. People look at us and say, "Are you serious? This can't be." So there's a clear lack of education there. And you are right. It is also a question of Congresses and us willing to take steps and to changes. We have to, as you pointed out very well, you don't want to be reactive. You don't want to just react, and this is what is happening in immigration law. We react. We don't think about the future. We don't think what is it going to be in 10 years. We look at what's happening today, and we're like, how can we fix today? Well, today, that's a Band-Aid. Does not resolve the issue. You have to look at 10 years, 20, 30 years down the road. And that's the problem with immigration law, is that it's not. We're looking at how to fix it today.
Churches censor discussion of politics, and newspapers limit everything to 500 words, and politicians spout out their stuff and don't really respond to emails or letters, or you just try and talk with them, and you might find it in a hamburger line, and you might get 5 or 10 seconds with them. So there's not much interaction there, and I'm wondering if a courtroom would be at least a forum where some of these myths about immigration might at least be vetted, where at least you get a chance to hear both sides of an issue and decide, for example, is population growth something to be feared?
Yes, and it depends on the case. That's really what it comes down to. One has to realize that the judges, any judge, whether it's state or federal, will control his courtroom. They will control what can be used and what can be said. We as attorney have to obey. We cannot disobey a judge. Let me give you an example. I had during the Marshalltown raid, I represented four women. These four women had all papers filed by some family members. I thought that my defense, in my defense, I needed to explain immigration law and to explain why these women were here, why they were using false papers, what was the interaction of them using false papers and being here, and I was ordered not to talk about it. Now, I had to obey. I had no choice to obey because the judge runs his courtroom. So it depends on the case. It depends on the judge. Is the judge going to let you talk about it or not?
Well, obviously that's been a big problem in the pro-life litigation. You do have the recourse of offers of proof, putting stuff in the record to be used for appeal, and you have the ability to publish your entire brief for public education.
That is correct, but most offers of proof are done without the presence of the jury, because so you are not really teaching anybody. You are just putting it in for another court. What I thought we were talking about is the teaching of people, i.e. the jury. The jury understands, oh, I see these are the arguments. Now I understand how to look at this case.
In immigration, you don't even have jury trials.
Yes, so you do. You can have jury trials, sure. It depends on the case. Now, when we're talking about immigration court, yes, you're right. That's a judge who makes a decision. But you can also have immigration cases in federal court.
O God, our help in ages past, our hope